The Federal Circuit's recent decision in Accorda Therapeutics may have made litigating secondary considerations a lot more difficult. What happened? Well, at the district court, not much. It was a fairly typical case. The district court analyzed obviousness, found a motivation to combine the prior art references, and found reasonable expectation of success. It's when it turned its attention to secondary considerations that things got interesting. The district court discounted Accorda's evidence of secondary considerations under the so-called blocking patent doctrine. The blocking patent doctrine isn't new. It dates back to at least 2005 in the Merck v. Teva case. In Merck v. Teva, the Federal Circuit rejected Merck's evidence of commercial success under the theory that Merck had a genus patent. According to the Federal Circuit, no one would have been motivated to develop the claimed method patents because of that blocking patent. But here, the district court went further. It applied this blocking patent doctrine not only to commercial success, but also to long-felt need and failure of others. But then the Federal Circuit went further, engaging in a lengthy discussion of blocking patents and their relevance in patent litigation. And then the majority announced a nine-factor test that district courts should consider in deciding whether or not a blocking patent is relevant to secondary considerations. One of those factors, whether or not the blocking patent could be successfully challenged, frankly interjects the concept of validity and infringement of that blocking patent into the litigation. And that's all true regardless of whether or not that patent is actually in the litigation. I won't go through all 9 factors. Suffice to say they're fact-intensive and raise the specter of conducting a mini-trial into that patent litigation over this blocking patent. Once again, regardless of whether or not that blocking patent is in the litigation. Oddly, the Federal Circuit seemed to agree. It admitted the inquiry may be, and I'm quoting here, difficult as a practical matter. More frustrating, the Federal Circuit admitted that even at the end of this inquiry, a district court may be left with, again a quote, only some evidence, weak or ambiguous, as to the strength of that blocking patent's deterrence. And finally, the Federal Circuit said that the district court may just have to rely on, again a quote here, a sense of whether or not the blocking patent is relevant here. So where does that leave us? Accorda may have broad impacts on the litigation of secondary considerations when there's a so-called blocking patent in play. At a minimum, you should expect to hear a lot more about this during patent litigation. Bottom line, litigating secondary considerations when a blocking patent is at play may have just become a lot more difficult. And I should add, Accorda just filed a petition for rehearing and rehearing en banc. So watch this space, and if anything changes, we'll update you in our monthly newsletter.